What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Friday. Happy Friday. Yay! Yay, it's Friday. Yay. Yeah. I don't know. You guys want to watch some court? Let's watch some court. No, that's not man. You guys want to watch some court? I want to watch some court. Let's watch some court. There we go. That's better. All right. What do I have on the docket this evening? I have got a court reporter getting fired. It's interesting. I've never seen a docket like this, or I've never seen this on YouTube, and it was very interesting. So I put it in the clip. I don't feel great about playing it though because we're literally watching someone lose their job. I don't know if it's final at the end of the hearing, but it's pretty much final. You guys are about to see, and then we have a pro se plaintiff. He decides to sue the city he's living in, and a bunch of police officers. We get to watch that happen. That's kind of fun. Then and we've got a bunch of Judge Clark pro ses. We've got the Nelson hearing. We've got a bunch of stuff tonight. We're gonna be jumping everywhere. Hopefully you guys enjoy it. All right. I don't really have anything else. Ooh, let's see what do we got. We're starting off with a milestone. Marty, thank you so much for the 22 months. I appreciate it. Thank you so much. 22 months. That is awesome. Thank you. All right. Let's go. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Now let's go.
Do we have anybody here for the second matter in the matter of Kelly? It doesn't look like it. So in that regard, I will take up in the matter of David Laurel, cause number 831, which is agenda item 3C.
On April 3rd, 2025, I, the compliance manager with the commission, filed a complaint against David Laurel, alleging that the respondent failed to timely file records with the Court of Appeals, the 5th District of Texas at Dallas. The complainant further alleged that the respondent's shorthand reporter certification was expired from December 1st, 2022 through June 23rd, 2025. During that period, the respondent served as an official court reporter for the 203rd Judicial District Court until his resignation in October 2024. During the investigation, a review of Thames revealed that between 2022 and 2025, the respondent failed to timely file the records in approximately 11 cases with the appellate courts, had defective or missing exhibits in approximately 6 cases, and was subject to no sit orders in approximately 3 cases. This does not represent the total of late records due to the unknown volume of hearings reported by the respondent during the period in which his shorthand reporter certification was expired. Due to the high volume of cases involving late records, the investigation report focused on appellate cases involving miscellaneous criminal murder, burglary, deadly conduct, aggravated assault, and capital murder of multiple persons. The respondent admitted during his interview that he was notified in December of 2024 that his license had expired in 2022. He further admitted that many of his records were late due to the enormous workload and that he served as an official while his certification was expired for possibly thousands of cases in Dallas County. The respondent also failed to update his contact information in the commission's database or respond to the investigator's request for information.
We did find a number of violations in this case. Government Code 154.101A, Government Code 154.101B1, Commission Rule 3.11B, Commission Rule 3.11C, and based on these repeated violations, we're recommending a permanent revocation. Also, due to the egregiousness.
The court reporter's there. He's just not on camera yet. He's about to jump up. Did she say he resigned? Was I reading chat when she said that? then yeah, I don't. Did she say that? Then I don't know why they vote at the end to see. Okay, let's just go. Sorry.
Mr. Laurel left us. There he is. Mr. Laurel, are you there?
I'm here. Sorry, I had to get another computer.
All right. All right, Mr. Laurel. You've heard the summary of the investigation. Again, we have a myriad of information in front of us relative to all the cases, well, some of the cases at issue. It appears that we'll never know the full extent of it. And is there anything in front of us that we don't need a recitation again of your interview or anything else, but is there anything else here that we need to be aware of that is not included in this information?
No, I stipulate everything you have is true and accurate.
Okay.
And yeah.
Nope. Sorry, I didn't mean to cut you off, sir. Please go ahead.
Oh, you did it. That's all I had to say.
Okay. Fellow committee members, is there any discussion?
Can I just ask, I know that Ms. Saucedo read that you were aware that your license was lapsed during that particular time frame, or you did not know that? You did know it was lapsed and you continued to sit, or you did not?
What time frame are you talking about?
Let me go back. I wrote down on my notes. Let's see. Oh, now you're gonna make me look through all my notes. Okay.
It looks like his certification was expired from December 2022 through June 2025. And then it looks like Mr. Laurel had said that he was notified in December of 2024 that his license had expired in 2022. And I believe that Ms. Smith had included emails from the licensing department to Mr. Laurel regarding his certifications status.
So I guess my question is kind of a basic one. Why didn't you renew your license when you got?
I had my years mixed up. I'm sorry.
So when it expired in December of 22, and you didn't renew it then, but then when you got the second notification at the end of 24, you still didn't renew it right away. So my question is, why were you not taking care of that?
It came to my attention in December of 2024. By the time I was gonna sign up to take the CSR, because up to that point, my understanding was I just had to retake the CSR. I had missed the deadline to register for it, so I couldn't do it till April. I did take less than a handful of depositions in January before it came to my attention that I couldn't at all. So I hope that answers your question.
And was there, and I'm sorry, there was almost 500 pages of stuff in here and I took a bunch of notes, but what happened in December of 22 when the commission sent out the notification to you that you needed to renew and your license was going to lapse? What happened between that and this next notification in 24?
I didn't receive the notification. Since 2022, I've had about 5 different addresses in 3 different counties.
Yeah, that's just an excuse. He knew exactly when his license expired. This is what I'm gonna guess happened. He knew it was about to expire. He's like, okay, and then he just kept putting it off, and then it expired. But he was still working. So now he's in a position where he doesn't want to tell anybody because he's still court reporting without a license. And so he just keeps kicking the can down the road, like, I'll get it I'll get it renewed, and hopefully no one finds out. Yeah, and then they do, and then they find out a bunch of other stuff he did.
I didn't get the notice. It is my fault. I take full responsibility. Like I said, I stipulate everything you have is true. I just totally forgot.
Mr. Laurel, do you want to continue reporting in this state?
Absolutely. I've reported every single day since June the 9th of 2014. I'm really good at my job. I love what I do. I don't want to not do it.
I mean, here's my question more for the committee though, right? He got licensed in 2014 and seemingly renewed all the times that he was supposed to until he didn't. And I get that he says that he renewed at the seminar, but then it wasn't brought to my attention until 2024. That wasn't it. Like, I could understand in theory if it was like your first year and it was the first renewal and like you were like, you were pretty on top of it in 2021. I said it's not this year, then that I mean that just from experience has to tell you that it's the following year. And so I mean,
Molly, that was the question I had at the, like, after I did the timeline, is this wasn't, Mr. Laura, this wasn't your first time to know that you needed to renew your license. If it was, I could completely understand that, like, you didn't get the process or whatever, but you had renewed prior. So you knew you had 2 years, you knew you need to get your CEs and you needed to turn it in.
Absolutely.
So I'm just trying to figure out where the disconnect happened, where you went so long with it not even occurring to you, like, oh, my license may have been lapsed. If you never got anything from the commission with all your moves and everything, giving you complete benefit of the doubt, did it not cross your mind? Like, wait a second.
Correct. I'm really, I don't know what else to say. There was no motive for me to do this. I didn't want to work unlicensed. I really just hate to admit, it slipped my mind. There's no benefit for me to do this. I hope you all understand that. It was just an honest mistake. I love my.
I really hope that's true, man. I really hope that's true. I just think he was kicking the can down the road and then hope no one caught it. That's they're going to talk about this, Patrick. They're going to talk about his cases here shortly.
My job. I've kept up with the license, like you said, up until 2022, since 2014. It was just a mistake.
And
I'm sorry. I renewed it right away as soon as I could. I got this little thing here.
I apologize.
You're not an official reporter right now. Is that correct?
Correct.
Okay. Sorry, Miss Salcedo, I cut you off.
No, I was going to address the issue of his renewal. He was actually late renewing about a month for his. It expired in 2017. He renewed almost a month after that. It had expired in 2020. I'm sorry, in December of 2019, I think, and he was late on that one. So it looks like he's been late on his renewals, but never to this extent of time.
My concern is the follows. We have the issue of him reporting and not being certified, which is problematic enough. And then there's everything else that's the rest of the 8 pages of the investigation report of all the cases that are late records and no sit orders and findings of inaccurate, I mean, not even inaccuracies, but missing exhibits and everything else. And so it's like, man, it's a 1-2 punch. Like, it's one thing to, I forgot my license and it lapsed and everything else. And it's another thing to then not have a license and have all these issues of late records and everything. And I know your response to that is that it is a very busy court, and I completely understand that. I'm sympathetic to that. I understand that it's Dallas, all of the things, court reporter shortage, on and on. We're very well versed in all of that. And so it's just, man, if it was one or the other, I don't know. But with the combination of them, I don't know what choice we have. And so I'm open to suggestions from other folks.
A MB or someone else that's way smarter than me, what is a no-sit order when it comes to a court reporter? I just tried to look it up real quick, and apparently I mistyped a bunch of things. Weird, right? But can someone let us know what a no-sit order is? In my head, that would be a judge saying that they don't want a certain court reporter, but I don't know if that's true. That's just a guess on my end.
Yeah, really quickly.
Let me actually get the input from the committee members first, if that's okay, and then I certainly will turn it over to you.
Okay.
My thoughts are the same as yours, Molly. I'm having a real hard time getting past all of the things that have occurred.
I mean,
feel the same way.
because we don't know. I mean, some of these cases are still on appeal and at different things, and I don't know what the implications are when a non-certified court reporter is in charge of your record, what that means to a defendant. And again, I'm looking at you official folks, I mean, what is the answer to that? Is there repercussions in that regard? Are they entitled to new trials? Do we have to start all over in this whole process?
I think that's a possibility, because technically, if you're not certified, your transcripts aren't admissible.
How many
And Madam
appeals you
Chair,
do right now? Sorry.
No one tell any SOBSIT cases that he sat for. No one tell them, because they're gonna have a field day on this. Jedi answered my question. No sit orders for court reporters generally refer to scenarios where a reporter is not required to physically attend sit for or stenographically report on a proceeding. Okay. But if he's specifically given a no sit order, that's what I think they were saying, that he was given it specifically. Maybe I misunderstood. But thank you, Jedi.
Was that directed to me, Ms. Tyndall?
Well, it's anybody that could answer that question.
Oh, sorry, I
How
didn't
many
hear.
appeals do you have due right now?
I don't have any due right now.
Okay.
Oh, I take it back. There's one pending that I took about 2 months ago in Tarrant County.
Madam Chair, the comment that I was going to make a moment ago is with respect to the downstream consequences as to the cases where the lapse took place. I think certainly that's something for the trial court to look at and for counsel for the parties to address. And they, I'm sure good lawyers will deal with that. The call for this advisory board and obviously for the commission is limited and restricted to action with respect to the respondent's license.
Thank you, sir. That is a good point to remember for all of us. So I appreciate those comments. I mean, I don't know. All right. Mr. Laurel, is there anything else that you would, I mean, you're acknowledging that this all happened and all of these other things. And I mean, is there anything else that you would like us to know or hear before we make a decision?
Yeah, I just want to make it clear. All the records that I was late on with the Fifth Court have been turned in. There's not been one record that I had to turn over to another reporter or I've done all of them. It was just a total lack of communication and not a very good relationship, reporter judge wise. I was not notified for most of these cases, and I developed a relationship with the clerk of the Fifth Court of Appeals. And I would ask her to find any cases that are pending to me, search by the court reporter's name. And I was always told there was none, I was up to date, until I would get a do not sit order or something along those lines. But every time a record was late, I turned them in.
All right, that doesn't sound like a really good excuse. I don't know how this works. I would assume and I would guess that as a court reporter, if someone asks for a transcript and you have the official report, that you should just turn it in. But why are you relying on a court clerk to tell you when you have to turn something in? That doesn't make sense. I don't know how it works though. I don't. I know I got a few super chats. This one's almost over, so when it's finished, I'll catch up. So thank you all for the super chats.
Madam Chair, if the respondent's completed, I'd be happy to close on behalf of the commission.
Yes, sir.
The comments that the respondent made at this time are illustrative of some of the challenges and deep concerns that the commission has with regard to his performance as a court reporter. We've had recent cases brought to this advisory board and ultimately brought to the commission that have resulted in a sanction similar to what's being sought by the commission in this case. And these allegations in today's matter are as egregious, if not more so, than those. Based on that, we think that the outcome that we're recommending as staff is appropriate, and we'd ask the committee to consider that.
Thank you, Mr. Morgan. Is there any more discussion amongst the committee members? Is there a motion that anybody would like to make?
Molly, I'd like to make a motion that we follow staff's recommendation of revocation.
Is it your motion that we find violations of Texas Government Code 154.101A, Texas Government Code 154.101B1, Commission Rule 3.11B, and Commission Rule 3.11C as outlined in the investigation, and based upon those findings, we accept the recommendation for permanent revocation? Is that what I understand your motion to be?
That is exactly what my motion should have been.
Is there any second to that motion?
I'll second.
Thank you. Is there any further discussion?
Oh, may I?
Very briefly, Mr. Laurel.
If the committee wants to go forward with that decision, could I just respectfully request that the final, or I don't know how to word it, the expiration of the revocation take place June 30th, 2027, which is the expiration date on this current license?
Mr. Laurel, what we're doing is we're going to make a recommendation to the JBCC, and ultimately they will decide. You will receive notification, like I said at the beginning, about kind of the next steps of that. This is step one, and that the recommendation then goes to the board. You will have an opportunity to request a hearing, to be present at that time. All of that information will be outlined from after the result of this hearing. I just encourage you to make sure that your address and email is up to date so that you can be sure to get notification of all of that. And so that your request right now is a bit beyond our discussion. And so certainly something that you can raise at a later date. To what end, I'm not sure. That being the motion as it was outlined, having been second, no further discussion in that regard. All those in favor of the motion as we talked about, please say aye.
Aye.
Aye. Those opposed? Mr. Laurel, it is going to be our recommendation as we've outlined here today. And again, you will receive further instruction. And for the third time, I encourage you to make sure that the address and email and everything is up to date so that you're aware of all of those things.
Got it.
Thank you for your time here today, Mr. Laurel.
Yeah.
You may drop off the call.
Okay, thanks.
Thank you. All right, moving on to agenda item.
Yeah. Why do I feel bad for that guy? He has such an important job, though. I shouldn't feel bad for him. I shouldn't. I feel like everything that they put into that hearing, he did it on himself. So I shouldn't feel bad for him, but I do. I don't like that. That he's going through that. But yeah, no, he needs to be on top of that. Can you imagine if they have to, if the transcripts can't be certified because he didn't have his license, and that changes the ruling of a trial? Could you imagine that? I mean, they suggested it. They didn't say yes or no to that, but they suggested it. All right, let's. Great Granny, thank you so much for the super chat. Hello, all. Here's my late fee. Thank you so much, Great Granny. Good to see you. And Colleen is Athena. Thank you for the super chat. Thanks for finding this, Colin. Very interesting. You are welcome. You are welcome. There were 3 court reporters on that YouTube video. That one was the most interesting. The first one actually was the one that happened right before his was pretty interesting as well. But the court reporter wasn't there. It was a mother who lost her appeal because the court reporter didn't get the transcripts in on time, and she had like $100,000 judgment against her. She paid all these attorneys, and she lost her appeal just because she couldn't get the transcripts on time. So she was looking for sanctions on the court reporter. But there was no end to that one, so that's why I didn't play that one. But that was interesting as well. Never seen something like that on YouTube. So I thought that's why I was like, I'm gonna play one of these, and that's the one I picked. All right, we're gonna move on. Next, we have a pro se plaintiff. Pro se just means you're representing yourself, but that's kind of a I've always thought that term was kind of reserved for defendants, but I mean I guess if you're still pro se, you're pro per, whatever. It doesn't matter. It's Friday. It's been a long week. You guys know what I mean. All right, let's go.
Calling case number 25017-083 Phillips versus Grochaki. This is the motion to dismiss.
Okay, sure. Anybody here in this case?
Yes, Your Honor. Eric Goldstein. Here for the defendants.
Okay. Anyone else here?
I see Mr. Phillips is phoned in. I see his square.
Mr. Phillips, are you, can you hear me? Mr. Phillips, you're muted if you're trying to talk. I don't, he's obviously here. Oh, okay. Mr. Phillips.
Hello. Good morning. Justin Phillips on behalf of plaintiff.
Justin Phillips on behalf of plaintiff. You're an attorney?
I'm self-represented.
Okay, so
Phillips v. Livonia.
I understand that, but when you say you're on behalf of, I just want to make sure. If you're not a lawyer, then I just want to clarify that. Okay. Okay. Go ahead, Mr. Goldstein.
Good morning, Your Honor. It's my understanding that there are two motions up today on two cases involving the city and Mr. Phillips. The clerk called the one that we understand to be the FOIA case, the Freedom of Information Act case. Mr. Phillips submitted a FOIA request. I believe it was like the 41st or 40th FOIA request he submitted. And in the time frame allowed by the statute, we sent him an extension letter. Mr. Phillips has miscalculated when things are due and filed this action the same day we sent him the extension letter, contending that we had violated the FOIA by not sending him a response within the calculated 5 days. We have fully briefed that issue, laying out exactly how the days work, the calendar work, the statute works, and presenting to you for consideration that we filed everything. We filed our response letter on time. Mr. Phillips filed a response to our motion that did not address this issue at all. His response sets forth his narrative wherein the city of Livonia, its employees, the police department, the 16th District Court, various Wayne County Circuit Court judges, police officers from other departments are all conspiring against him to deprive him of his rights. But he did not address the issue that the FOIA was timely submitted, which was the only thing this case was about. So I filed a reply brief pointing that out, walking through, again, how we timely responded, which was all the lawsuit was about, and arguing further that he has essentially abandoned any argument to the contrary since he did not address it. And I think that's the nutshell of what's in front of you.
All right, Mr. Phillips, your response, please. Mr. Phillips, you're on mute, sir. Mr. Phillips. Mr. Phillips?
Yes, I was unmuted and then someone muted me. So
but you could
hear me.
I can hear you, but did you hear everything that Mr. Goldstein was saying?
Yeah, much of it is a hot mess. I'm not sure what he really is stating. Everything was addressed and it was very direct to himself as defendant and the city of Livonia, not other departments. So I'm a little thrown off in regards to whatever he's referring to. in regards to the actual matter regarding the FOIA, yes, FOIAs were entered, Your Honor, and they did not timely respond. I filed the lawsuit preceding their response. So if they happen to file a response or reply in regards to the FOIA request, that's just what they did. But mine was obviously timely filed, and they filed afterwards, and that was addressed. And so I do object to everything Eric Goldstein states, and it's very unfortunate that he has animus.
It's very unfortunate. Very unfortunate that he has animus. Is that what he said? The smile on the attorney's face is priceless. Though it's like I don't know why I'm dealing with this guy. So he filled out a bunch of FOIAs, and he didn't get them in time. So he filed lawsuits. I mean, I guess that's an option. That's a decision you can make. That has anyone ever filled out a FOIA before? I have. I used to try to get body cam footage of people in court and realized real quickly that I was in way over my head because filling out FOIAs and dealing with police stations and courts trying to get video. It was a headache and a half. And when I did fill it out correctly, I would get a letter back saying that they would ask for an extension. Here's an extension. We're gonna this is our right to say that it's going to take us 90 more days to get you the footage, whatever it was. And then 90 days would pass and you get another letter saying the exact same thing. It was a mess. So I just like, no, I'm not doing that anymore. I'm not doing that anymore. Way too much work for what it's worth. Especially if they're not free either. So yeah, I don't know what this guy's suing for though. Yeah, FOIA. Okay, good luck with that.
Okay, thank you. All right, the court has read the pleadings, and the court's going to grant defendant's motion under MCR 2.116, parent C, parent 10. The undisputed record establishes that the city of Livonia timely issued written extensions and substantive FOIA responses in compliance with MCL 15.235. Plaintiff presents no evidence creating a genuine issue of material fact regarding FOIA timeliness or entitlement to relief. Because defendants are entitled to judgment as a matter of law, dismissal of plaintiff's claims with prejudice is appropriate.
Thank you, Judge. We will submit an order. We'll submit one.
Thank you, Mr.
Thank
Phillips.
you. I appeal. Thank you.
Thank you, sir.
Shall we move to the other motion, or
that's
are
not
you
my
aware of the
call.
other motion?
I'm aware of it. It's up to my clerk. So
We have two more general motions to call, and we will start with the MSDs. Are we ready?
Yeah. That's not the only bite at the apple that guy took. He filed so many lawsuits that he's on the same motion calendar for the same judge with the same attorney. Oh, this is great. Okay, part 2. Completely different case. Let's go.
Okay. Calling case number 25015-868, Phillips versus the City of Livonia.
Good morning, Your Honor. Eric Goldstein again for the City of Livonia.
Mr. Phillips. Mr. Phillips, can you hear me?
Good morning,
Mr. Phillips,
Good morning,
can you hear me?
Justin Phillips.
Oh, okay. Just want to make sure you're with us. Okay.
Yes.
Okay, go ahead, Mr. Goldstein.
Thank you, Your Honor. This is a motion to dismiss. The background is this: plaintiff filed a complaint that was in narrative form. It was not in the standard form of numbered paragraphs with distinct facts that could be admitted, denied, or neither admitted nor denied, as we traditionally and customarily see. It was a long narrative in paragraph form, and it named 39 distinct defendants. And it was not at all clear what was being charged against each individual defendant. It made it impossible to respond. So we filed a motion for more particular statement, which Judge Lillard granted. And at the hearing, Judge Lillard asked Mr. Phillips how much time he would need to prepare an amended complaint, broken down like that, so each of the defendants would know what they were being accused of doing or failing to do. Mr. Phillips said he could get it done in 3 weeks. This was all last year, as I've indicated in my motion. The 3-week deadline came and went with no amended complaint. On the very last day of that 3 weeks, Mr. Phillips filed a motion for more time. For reasons escaping my understanding, Mr. Phillips never did the necessary procedural actions to get it scheduled for hearing. In any event, I filed a response objecting to that. And after the passage of more time, I brought this motion. And the motion that's before you, Judge, demonstrates that Mr. Phillips has had the capacity and capability of preparing that complaint. In his motion to, in his unheard, unscheduled motion for more time, he sets forth that he's been ill, he's involved in some type of FBI investigation, that he's busy. He's busy. And in my response to that motion, I suggested that the case should be dismissed without prejudice so that when he's ready to proceed and give this case a priority, he can refile. Well, that was my response to his motion that was never scheduled by him and thus never heard. I filed this motion after the passage of time and after seeing Mr. Phillips file many substantive briefs and complaints. We have numerous docket numbers going on with him, civil docket numbers in state court, civil docket numbers in federal court, and various filings in this court's criminal division appealing lower district court convictions. He's demonstrated capacity to do all kinds of work, and he hasn't taken advantage of the opportunity to prepare the amended complaint in all this time. He has not even responded to this motion. He's here today, and I'm glad, but he has not responded to this motion. And I would submit that by ignoring the briefing opportunity, he has waived his ability to argue today for yet more time. I think this has been going on long enough, and I would ask that this court dismiss this case with prejudice. Thank you.
Thank you. Mr. Phillips, did you file a response?
Yeah, so much is going on. What did he say? 49 complaints of different people. The FBI, oh, he's dealing with the FBI. I'm guessing that's a separate matter. What? Yeah, it sounds like he's pretty busy. I don't know. Like, yeah, we're all busy, man. Don't file a lawsuit and then be like, hey, I'm busy, I can't do this. Okay, we're on your schedule. No, we're not.
Response?
Your Honor, I did not file a response. I have been severely ill, and I did let the court clerk know at length in regards to such, and I haven't heard anything back.
You say you've been sick. I'm sorry to hear that. Were you in the hospital, can I ask?
I was not admitted, but I had several ER visits.
Okay.
And I did notify the court of such. The premise of the matter, which is relative to the FOIA matter that was obviously dismissed with prejudice, is that these defendants have caused harm, and it's in regards to avoid ab initio quorum non judice issue regarding a parental custody matter where they placed animus against me as father as targeted parent and turned around and shielded the mother. And so there's multiple defendants. And because of my illness, I was not able to specifically identify certain things, but I have made progress, and I do intend to reply if there is more time that could be granted. Or, Your Honor, I do, agree if it is dismissed, if it could be dismissed with prejudice, or I'm sorry, without prejudice, so I'm able to refile everything and have everything in order. If not, I do request that I get more time.
Did you ever
but
go
I do
to,
just,
did you ever contact Mr. Goldstein about getting an extension?
we've spoke. He sent me messages, but then he became very nasty, if you will. I don't know a better term to say. And so at that point, the contact had
Oh, Java Puppy, I'm on it. I'll do it. Making it right now.
ceased, just because he's disgruntled because of, again, the other filings that he stated are relative to his misconduct solely of
When was
himself,
this
as well as
motion filed, Mr. Goldstein?
This motion to dismiss was filed on January 13th.
Okay, so that's 5 weeks ago. Okay. Right. And did Mr. Phillips ever ask you for more time to respond?
He has never asked me for more time to respond.
Did he tell you he was sick?
He often tells me he's sick.
Did he tell you he was sick since January 13th? And that he couldn't file a response in time?
No.
Mr. Phillips, did you ever tell Mr. Goldstein that you needed more time to file a response? Did you or not?
Your Honor,
That's a
other
simple question. I mean, I'm just asking
I'm going
you
to
a
say
question.
yes.
I'm asking you a direct question.
Yes.
When did you ask Mr. Goldstein for an extension to file your response to this motion?
It would have been the second or third week of January, and my most recent ER visit was 2/14 of this year, Valentine's Day.
How much time would you need to respond to this motion, sir?
Your Honor, if I can get 2 weeks, 3 weeks.
Are you feeling better? Is that
I'm feeling a
why now?
little
Are you-
better. Yeah, I'm feeling a little better, but I'm sorry, I heard something.
I'm
feeling
I
a
don't
little
mean
better.
I don't mean to ask
Go ahead.
personal questions, but given what's at stake here, do you have any problem telling me what's wrong with you? If you don't want to talk about it, that's fine, but I'm just curious as to what's preventing you from responding. The fact that you don't feel good, or you said you almost went to the ER. I'm not sure.
Oh, no. I went. Yeah, I know. I went to the ER, and I do have a physical medical condition. However, these defendants have caused a serious counseling psychological injury where I'm interacting with my counselor in regards to such. And based on the animus received and the distress that I've incurred, that is what had caused all of this delay. But things are progressive. I'm moving forward and able to complete the task of naming exactly all the allegations, factual allegations for each person.
Sir, I don't know what you're talking about. Let me just focus in on the issue at hand.
Go ahead.
There was a motion filed by Mr. Goldstein. He properly filed it. You didn't respond. You're saying to me, I was sick, I couldn't respond, and I want to respond. Isn't that what you're saying? To the motion?
Correct.
Okay. And you say you need 2 weeks to respond, correct?
2 to 3 weeks. Yes, Your Honor.
2 to 3 weeks. Okay.
And
why 3 weeks? Why not 2 weeks? I mean,
Your Honor,
normally you get a week to respond. That's what the lawyers get.
Your Honor, if 2 weeks is the max, I'll take it.
I'm just trying to work with you, sir. You haven't responded. I wanna, I want you to be heard with a response. If you feel that you're being denied a fair shake here, but what concerns me is that Mr. Goldstein, although you say you asked for an extension, Mr. Goldstein says you never asked for an extension. And so I don't know who's telling the truth or not, but I don't have a problem letting you have. So here's what I'm going to do. Mr. Goldstein, I know you're not happy with me, but I'm going to give him 2 weeks to respond. And I'm not going to give any further adjournments. And after you respond, I think, Mr. Goldstein, I think you'll just be able to notice it up. Why don't let's set it off for what, 3 weeks from today, and then you will have a chance to respond to plaintiff's response to your motion. Is that okay? You don't have to respond, but you may want to, Mr. Goldstein.
So today being the 20th, Mr. Phillips needs to respond to this motion by March 6th. And Judge, are you saying we should come back on March 13th?
Anytime after that you're good with, and that's good for Mr. Phillips.
I'm good with
I don't care if we
March
do it the
13th.
13th or the 20th. I don't care.
Why don't we just do it the 13th, Your Honor?
Mr. Phillips, you available the 13th?
If we can come on the 20th?
Well, what's the problem with the 13th? Do you have a conflict?
One moment. I'm just looking at the calendar again. Let's see. Sorry for the delay. That's the Friday. No, that's another Friday. Yeah, the 13th isn't good, but is Monday okay? The 16th?
Is the 13th bad because you have another obligation, court hearing? What do you have?
No, I have on Fridays. I have counseling in regards to this situation on Fridays.
That's fine. All Fridays?
Correct.
Okay, today's Friday. Does that mean you missed your counseling session?
No, it's a little later.
Okay.
It's at 1 o'clock today.
And it's not going to be at 1 o'clock on the 13th?
No.
Okay.
It's going to be in the morning.
Okay. All right. So when do you want to do this, sir? Mr. Phillips?
Oh, if the 16th works for the court and Mr. Goldstein.
Which day, sir? I'm sorry, I missed that. What day is
Monday,
good for
March 16th, I think is what
Monday.
he's asking
Well,
for.
we do motions on motion day. So
I'm not sure if Mondays are motion day, but I was only saying that
Friday is motion call in Wayne Circuit. That's why we're here today.
Oh, okay.
It's Friday. Yeah. If you can't be here on any Friday because you have counseling, then I suppose we'll put it another day. But I think this is a case that Judge Lillard should handle. She probably, she's an expert on these kinds of cases. Don't you think, Mr. Goldstein? Yes.
I agree.
Let's
I
set
agree,
this
Your Honor.
off to Miss Davis. When's Judge Lillard gonna be able to hear this?
So this judge is a pro tem judge. He's retired. You see the RET next to his name. I don't know where the sitting judge is, but yeah, that's his way of saying, you know what? I don't even want to. No, we're gonna wait till the judge comes back. That's hilarious.
Seth, what's the date?
Let me check.
Yeah, let's set it off for her.
Sorry for any confusion.
No,
No
you're
worries.
fine, Mr. Phillips. We're trying to work with you. That's what we do.
I guess to ensure the greatest chance of her actually being back, probably April 3rd.
Is April 3rd good for you, Mr. Goldstein?
Checking.
Is that a Friday?
That is a Friday, Judge.
That is Good Friday, Judge, and I'm available.
Mr. Phillips, do you think you could be here?
Oh, that is
morning?
Good Friday.
Does that mean we're off? I think there's only
No,
a half
we're-
a day. I think
Let
you
me
guys
check
work
that.
a half a day.
Possibly,
Yeah,
let me
good.
check.
I'll make sure that
Okay,
I'll do it.
okay.
I'll be
So
there. Yes,
so it'll be 8:30 or 9 o'clock on that date, or whatever you
yes.
say, Seth.
If the judge is back, it'll probably be at 9.
9 o'clock. Okay. All right. See everybody then.
Judge, just to
Thank
make
you.
sure I get the order
Oh.
right, Mr. Phillips has 2 weeks from today to file a response to my motion, and we are coming back on that date in April 3rd at 9 o'clock. Is that correct?
That's my understanding.
That's what I'll put in the order. Thank you,
Mr.
Judge.
Phillips, Mr. Phillips, you're in agreement that that's
Yes,
okay, good. Thank you. Thank you both.
yes.
Have a wonderful weekend, Mr. Goldstein, Mr. Phillips.
Take
Thank
care,
you.
Judge.
You too.
Thank you.
Bye.
Bye.
Yeah, that one was kind of frustrating. Yeah, that he's definitely not a subset. Could he potentially be a frauder? Yeah, he could. That's what I thought when I was first listening to this. It sounds like one of those people that just do things just because they can. I mean, even though you know why, just because you can do something, why do it? Okay, well, I ended the poll. Let's see. So the winner is just weird. Okay, so my vote was for frauditor, came in second. Just weird at 47%, frauditor at 35%, smartest person in the room at 12%. Okay, broken system, broken trust was in the chat, so he definitely voted for that. Soft sit came in last. Yeah, he wasn't a soft sit. If he was a soft sit, that would have been on the thumbnail. That would have been all over the thumbnail. Like, I found another soft sit 2 days in a row. Let's go. Anyways, you know what? Let's just move on. I think we're gonna end with a bunch of Judge Clark hearings. We're gonna start with a Nelson hearing. Guy's trying to say his lawyer's incompetent or not representing him well. Not that his lawyer's incompetent, just not representing him well. And then we got a couple pro se hearings with Judge Clark. Let's go.
Yeah, he's coming. Oh, thank you.
Governor Chris Scott here on behalf of Mr. Griner. We're here for a Nelson.
You swear Mr. Griner in?
I do.
Mr. Griner,
Yes, sir.
what request are you making today?
I've had Mr. Scott for 5 months. It's the first time I've met him in person. I've had 3 court hearings. Charles Williams has stepped in every time for him. On December 18th at 9 o'clock, Mr. Williams pushed me from in front of the podium, and covered the mic up so I couldn't speak into it when I asked to speak to you on the record for this Nelson hearing. I wrote the Florida bar against Mr. Scott and Charles Williams. That's the only time he came and videoed me was after January 5th of 2026 to see me for under 5 minutes, and we did not get to discuss my case. I've been in the jail for 8 months now. I have discussed my case with no attorney. I pray that the court would assign me a different attorney that has the credentials as well as the time to take my case over.
Your response?
Your Honor, with regards to the communication, I've had Zoom video visits with Mr. Griner while he's at the jail. Additionally, there is a court-appointed investigator that's assigned to the case by the court. His name is Wes McCarroll. Mr. McCarroll has been out to see Mr. Griner as well in person. It is true that Charles Williams has covered for me at some of the pre-trials. However, we are progressing the case as far as where the case is. We've completed a round of depositions. I've been working with the state to identify which cases are going to trial first. We have those witnesses deposed. Through the depositions, there was some additional discovery that we discovered was not provided. That has been provided by the state, so we're working through the case. I believe I have the discovery. And where we are now, Judge, if the court leaves me on the case, and I believe that I have been progressing the case in accordance with what I'm supposed to do. Now that I have all the discovery, now that we have everything available to us, I can meet with Mr. Griner, go over all the discovery that we have. If the court leaves me on the case today, my request is going to be to set it for trial. So we are progressing the case to the point where we get it set for trial.
What I'm gonna do is I'm gonna take this under advisement. I do want you to go out to the jail and see Mr. Griner.
Sir.
Make an in-person visit
Yes, sir.
I'll reserve this to March 27th, the motion day, and see where we're at that time, okay?
Thank you, Judge.
Taking under advisement.
That concludes my business. Thank you, sir.
Mr. Crown, you understand that? I'm not
Yes, sir.
denying your motion, I'm just taking under advisement.
I know, wrote the Florida bar against this guy, so he's already got and I mean,
The Florida bar don't determine who takes the
And-
cases or not, but that's.
how he says, Mr. West come out there to tell me that he was out there for a meet and greet, not to discuss my case. The man is,
I'm gonna say it March 27th, and we'll see where we're at then, okay?
yes, sir.
Thank you, Judge.
Yes, sir. Ms. Bennett?
Oh, I did put the next case divider in. Real quick, as you guys probably already figured out, my chat's frozen. It's been frozen for 15 minutes. No, I can't do math. Oh, wow. All I have to do is say it's frozen and it pops back up. I've been waiting to be able to highlight a very important person on the channel. Phil, thank you so much for the 5 gifted memberships. Welcome to the 5 new members. Thank you so much, Phil. Yeah, Bill. Thank you. And Bill coming in. Thank you, Bill. Good to see you. Bread, cheese, and butter fun. Man, don't do that. I want a grilled cheese now. Don't do that. Don't do that. I do appreciate the super chat though. All right. Yeah, what's weird with Judge Clark is that I've seen in. No, hold on, let me step back a little bit. When a defendant writes the bar about their attorney, usually from what I've seen, the court will just automatically, okay, well, you obviously aren't going to be able to you're not going to be able to represent this person if they just filed a complaint against you. Maybe that's why he did it, to try to get him off his case. But yeah, I've never seen a judge say, nope, has nothing to do with me. Keep on going. All right, we got 2 pro ses. Let's go.
Would you like to do John Clark in this statement?
Yeah, John Clark. Mr. Clark?
You leaving? You leaving, Phil? Why are we saying see you Sunday already? We still got about 10 minutes left. Let's go.
Just for the record, I did let her know I'd be handling it this morning.
Okay, good. Thank you, Ms. Downey.
As long as you were okay.
I'm fine with it.
Okay.
Yeah, don't worry. I'm so confused right now. My chat was frozen for so long, and then it wasn't, and then it was, and then it wasn't.
Mr. Clark,
I don't
you
know what's going on
representing
either.
yourself. Do you wish to continue to represent yourself?
Yes, sir.
All right, you may proceed. And I've reviewed your pro se motion for statement of particulars and the state's response.
Yes, sir. This is the first time I'm seeing it, so I would like an opportunity to review that and, just to let the court know that I was acting under the directive of the court. I have court order and we returned all notices from the court in the foreclosure as deceased. And from my understanding, once
I got no idea what you're saying. I don't know what you're talking about.
and the foreclosure,
I got no idea what foreclosure you're talking about.
Well,
I don't know anything about this case except what's in the state file. I don't know about a foreclosure. I know nothing about it, Mr. Clark.
All right,
Not
sir.
one single thing.
I was arrested for resisting arrest during a writ. And after that writ, I was ordered back to the residence and 7 days later arrested for burglary. I had no idea I was doing anything wrong. I was acting under the court's directive.
You're not acting under this court's directive.
No, sir, it was the court's.
Make that clear.
Yes, sir. I was acting under the pretrial release order, ordering me not to change my residence.
But Your Honor, the defendant was.
Oh, no. That argument is not going to. Are you saying that you were evicted or from a residence and that's the residence you gave down on a, explain your argument real quick.
I didn't give any.
No, I think we all know what just happened there. So he was evicted. So there was a foreclosure. Someone passed away. He lived in the house. There was a foreclosure, and when the sheriff came to evict him, he got charged with resisting arrest. part of his pretrial release was, you know, he had to write his address down. Apparently, he had to write an address down, and maybe I don't know if he was on home confinement for whatever reason. I don't know what his background is, but that's the address he put down. So now he's going back to the house that he was just evicted from, charged with resisted arrest, goes back there. A week later, he's charged with burglary. He's not supposed to be there. This is a mess that you made, my friend. I don't know if you were trying to be slick, but that's not going to work. Yeah, it's not going to work. Judge Clark saw that real quick. He's like, "Oh no, 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 no."
The address. They just court ordered me.
Who court ordered? What court order are you talking about? Is that a pretrial release?
Yes, sir, from the misdemeanor. I mean,
Oh man,
I had no way of knowing I was doing anything wrong. All the bills and everything were still in my mother's name.
I guess that's what we're arguing about is that, but I don't know what you're talking about. So
I mean,
you're here today on a statement of particulars. You want a chance to review the state's response?
Yes, sir.
All right, I'll give you to March 27th at 9 o'clock.
All right, thank you.
You can. I don't know if I can answer or not.
That's the correct address?
Yes, sir.
All right, sign name and phone number.
Yeah, we got two back to back here, so I didn't cut this out. Yeah, that's he tried to pull something shady. He knew what he was doing. There's no way he didn't. And then he comes before Judge Clark and with that argument. That's
okay.
I mean,
all right, let's call her.
Out of all the dumb things you can do, that's actually kind of clever. If you think about it, it's like, oh, if I do this, they can't evict me. I'm gonna get more time because I'm under court order that they have to let me. Yeah, and then you got charged with burglary. Good job, my friend. But the thought process makes kind of sense. It just doesn't work that way.
Hernandez, real quick. State via Richard Hernandez. Come on up, sir. All right, Mr. Hernandez, you're before the court today. You're representing yourself. Do you wish to continue to represent yourself?
Yes, Your Honor.
All right, we're set for motions this morning. What motions would you want to hear?
Motion of particulars I've never received. I've never received any videos from the law enforcement, from their body cams or their vehicles or the witness. Then the video that I did get from them was from a third party 911 call, and then 4 videos from other people's cases that I don't even know who they are. They just on my DVD.
Did you get a DVD?
Yes, yes, they allowed me to view it. I've got the names of the people that are on that DVD.
You're indicating it has nothing to do with your case?
No, they're 4 different cases. One's a family law case. One's an arrest from Panama City Police Department arresting 2 people in a Chrysler, and then there's 2 other cases of. I've got their names here. And they even gave me Social Security numbers and everything on the Bay County Jail.
Direct somebody to go out there?
No, Your Honor. I don't know what is referring to, and I don't know what family law stuff. I wouldn't have provided any family law stuff.
It's all on there. I mean, I've got it.
All right, I will say this. Sometimes watching court all day long, you get annoyed with the process. And I understand why they're going to have to ask him all these questions. They gave him the wrong discovery. You got the wrong DVD. Does it matter how it happened? No. Do we have to have that investigation right now? No. You got the wrong DVD. Just reset the case. That's all you have to do. But we're gonna spend 5 minutes trying to figure this out, and it's kind of funny though. Yeah, DVD. That's what they get in jail, I guess. I don't know.
Okay, one was Duval and Cloud, which was Michael Overstreet was the judge there involved in that one. And Mrs. Cloud was there. And then another one was Ivy Coing. Case number 2021-04-6924.
I recognize
The
that.
other one was Tyrone Irvin, 2021.
When did you showed it?
This was probably 2 weeks ago.
I don't recognize any of those names. They're not associated in any cases I'm prosecuting, Judge. I don't know what he would have been shown or why.
The only, on top of that was just a 911 call from this case, which.
Yeah, it might have been entertaining. He probably got a DVD of a bunch of body cam footage. It's like, oh man, get some popcorn. This is good. It's not me, but it's good.
It had, somebody else.
Is there any other videos or anything that is discoverable?
There may be body cam, Judge. If there is, he'll have to request that directly from the agency itself. Beyond that, all the discovery's been provided.
Who's the arresting agency?
Panama City Beach Police.
Who came out who did you review? Who reviewed that information with you?
It was the classification officer, Williams.
Okay, it was somebody who was an employee of the jail.
I had to put a request in to be able to see it. But
what agency did it come from?
It came from their office right after the court when I had asked for that I hadn't received my discovery. It's been past the time limit. And right after I got back from court, they called me and handed me this paperwork I've got in front of me. And then
that paperwork, is that the discovery right there?
the DVD. Yes.
There's a response that was filed on January 22nd from the state.
I haven't.
Yeah, this is the discovery. But if he was called in right after court, I wouldn't have had time to go back to my office, run a disc, and get it out to the jail. Like whatever they showed him would have been out there prior to. I don't know what he was shown.
It was received right then and there. I mean, I had to sign for it from.
I'm not saying.
Yeah.
I'm not saying. I'm just saying. I don't know what it is.
Mm-hmm.
If there's body cam, you have to on that body cam.
There's one body cam video on that from not even my case.
If there's body cam on your case, you have to request that directly from the Panama City Beach Police Department.
Mm-hmm.
Do you want to do that?
Yes, please.
Okay, well, you need to do that yourself. I can't help you do that.
Okay.
All right, so you'll have to file the paperwork, or file the response, or file the request to the beach, okay? I'll set this for March 27th to see where we're at on that. Anything else?
Like I said, statement of particulars, and then.
You reviewed that?
I don't know that I was served. I've not seen it, Judge.
There's one in the file. Have you served that with the state, Mr. Hernandez?
Yes.
There's a pro se motion for statement of particulars, pro se motion demand for discovery, pro se motion for adversarial preliminary hearing.
Mm-hmm.
Do you have any of those?
I see them in benchmark. I don't know that I got copies of them, but I do. I can pull them up here. As far as the motion for statement of particulars, I would, our response would be, Judge, that the information and the discovery provided to the defendant is sufficient. It appears, Judge, that he was arrested on 9/22 and
Information was filed on October 9th.
yes, which would be under the 21 days. So I would ask that the motion for adversary preliminary hearing be denied as well.
All right, I'll do that. I'm gonna deny those based on that time period. And there's a motion to set bond. His bond does need to be adjusted, it appears. He's got maybe not.
It may, Judge.
There's $100,000 on kidnapping. You didn't file
I
kidnapping.
did not file. I filed false imprisonment.
All right, that kidnapping will come off. So that's $100,000 that will be removed. If he's caught with false imprisonment, tampering with a witness, and resisting officer without violence, so his bond will be 10,000, 15,000, 16,000. So your bond's gonna go down from 120, 125, 127 to $16,000. Okay? We're leaving on March 27th at 9 o'clock. And for you to request that information from the Beach Police Department, okay?
Okay.
All right. Anything else?
To be able to get my, my wallet with my bank card and all my,
As you're going to have to do that with the jail. I don't have any,
well,
it's
it's over at the Ark where I was living at.
Yeah, I got no control over that. All right. That'll conclude the hearing. Good luck, sir.
All right, thank you, sir.
Hey, he didn't do that bad. He didn't. He got his bond reduced by over $100,000. What did Judge Clark say? 127 down to 16. I mean, he didn't. You know what? I will say this: good for Judge Clark for just going through the motions. Most, no, I'm not gonna say most. A lot of judges won't. They wouldn't even have brought that up because there wasn't a motion for bond. There were the three motions that he filed. One was for the statement of particulars. The other one was for the discovery. The other one was for the adversarial hearing. They did the bond thing on their own. At least I didn't hear the defendant ask for it. Anyways, yeah, he might be getting out of jail. 127,000 to 6. I mean, that's still a lot of money. Still a lot of money. Yeah. Anyway, you forgot he was pro se, Patrick. Yeah. No, they kind of took over at the end. They just kind of did everything. But that's all I got tonight, guys. I appreciate you guys hanging out. It was a great show, a great showing for a Friday night. Friday nights are usually my slowest night of the week, but you guys turned out tonight. I really do appreciate it. Thank you so much. All right, we're gonna play our game. Who we're gonna raid? I'm gonna list all the people off. We've got 4 options: Katie Zed, Lone Wolf, K-Far, Artie. First one I see. I've got my phone on, so if my chat freezes, we're going. Phil, Phil, I think you have the fastest internet connection on the planet. Yeah. Phil always wins this. All right, but I'm not going to back out. I think I'm going to have to ask Phil not to play next time I do this. You know what? Screw it. No, I can't. I can't back out. That's what I said. First one I see. I haven't rated K-Far in a while. I'm kind of itching to rate K-Far since we go to Katie's Ed all the time. But I'm gonna stick to my word. I absolutely said first one I see, I'm going. I'm not backing out on that. Thank you guys for hanging out with me tonight. I appreciate it. Thank you guys for the super chats, the gifted memberships, the membership milestones. You are all awesome. And mods, thank you as always for your hard work. I appreciate that as well. Have a great rest of your evening. I will not be live tomorrow night as it is date night. I will be back Sunday evening at 8. And yeah, enjoy your weekend. Don't do anything dumb. You don't want to be on my channel. Trust me, you don't. Especially as a court reporter. All right, that's all I got. Go tell Katie that I said hi. And until next time, bye. Okay, bye.
Is